So without further more taking of your time, Mark, the mic is yours.
Okay, well, thank you very much, Krina, and good afternoon to everybody, or good morning, depending on which side of the pond you're currently in. My name is Mark Camilleri, and I'm a Canadian and EU lawyer in Brussels, as Krina mentioned, but also the president of the Canada-EU Trade and Investment Association, or CUSHA. CUSHA is a Brussels-based not-for-profit organization that aims to advance the Canada-EU economic relationship for the promotion of the Canada-EU Comprehensive Economic and Trade Agreement, or CETA, and the wider Canada-EU policy dialogue on issues of mutual interest and importance, such as today's on data regulation. CUSHA is proud to partner with the Center for European Studies at Carleton University and the CN Tellier Chair on Business and Public Policy at the University of Ottawa on this event on EU data governance and lessons and consequences for Canada. This discussion is timely, not just because we're on the eve of International Data Privacy Day, which takes place tomorrow, but because the issue of data regulation is very much at the center of many policy discussions, legislative proposals, and administrative actions, and it is at a real transition point in both the EU and Canada. For some years now, the EU has been a leader when it comes to governing data and the digital economy, a role that the EU seems to have embraced as part of its broader geopolitical agenda. With the introduction of the EU's General Data Protection Regulation, or GDPR, which has been in force since 2018, the EU was seen as setting the global gold standard in terms of the regulation of personal data. The GDPR has influenced data protection legislation and regulations around the world. Compliance with the GDPR's provisions by non-EU countries and organizations is seen as important, both in the context of allowing personal data flows out of the EU, but also because businesses see an economic case in adhering to these standards, from streamlining regulatory compliance to the highest standard, to meeting customer demands and expectations. Beyond, and on the back of the human rights approach of the GDPR, the European Commission has presented, or is in the process of presenting, a suite of new legislative proposals as part of its ambitious digital and data strategy, most notably the Digital Services Act, the Digital Markets Act, the Data Governance Act, the Data Act, and a regulation on data on artificial intelligence, just to name a few. Canada, in turn, is in the process of a significant refreshing, if not rebooting, of its own data protection laws. The current federal regime of personal data protection in Canada is the Personal Information and Electronic Documents Act, or PIPEDA, which was introduced back in 2000. While the Canadian data protection regime is currently considered as adequate by the EU, a review of that process is currently underway, with many experts being of the view that Canada's current regulatory framework does not meet GDPR requirements. Efforts by the last Canadian Parliament to introduce an update to the federal privacy laws in the form of Bill C-11 died on the order paper with the calling of the last federal election. But it is expected that a new legislative initiative will follow. In the meantime, the province of Quebec, inspired by the GDPR, has revised its privacy regulations to a more robust data protection regime. The province of Ontario is also looking to potentially introduce its own legislation. Now, given the importance of EU rules on global data regulation and Canadian data regulation in particular today, this webinar aims to take stock of EU regulation, where it is, where it may be going, with a view to trying to understand and anticipate EU's actions regarding the digital economy and what its governance might mean for Canada. We will take a look at Canadian data regulation, specifically in the context of personal data regulation, and see what lessons Canada might draw from the EU experience. Now, to help guide us through this exercise, I have the honor and privilege of moderating a very highly distinguished panel of European and Canadian experts. By way of a very brief introduction, I'm pleased to welcome Kristina Irion. Kristina is an associate professor at the Institute for Information Law at the University of Amsterdam. Hello, Kristina. She's commented on key developments in EU data protection law, and her current research agenda focuses on the governance of transnational digital technologies and global data value chains from the perspective of European law and international economic law. Also with us is Martynas Barysas. Martynas is a director for internal market at Business Europe. His main responsibilities are to oversee the development of the organization's positions on the free flow of goods and services, the digital economy, better regulation, and single market governance in general. Martynas has worked at the European Parliament's Committee on Internal Market and Consumer Protection Secretariat and has extensive experience working with the European Council. Also with us is Chantal Bernier. Chantal is a lawyer in the Ottawa office of the law firm Dentons and heads its Canadian Privacy and Cybersecurity Practice Group. Prior to joining Dentons, Chantal served in many senior government roles in Canada, including Assistant Deputy Minister for Public Safety Canada, Assistant Privacy Commissioner, and of course, as Privacy Commissioner of Canada. Welcome, Chantal. I also welcome Mark Agnew to the panel. Mark is the Senior Vice President of Policy and Government Relations at the Canadian Chamber of Commerce. In this role, Mark manages the Chamber's policy department and advocacy agenda domestically and internationally. Prior to joining the Canadian Chamber, Mark worked for the UK government on trade and economic policy issues at the British High Commission in Ottawa. Mark has also worked for the Canadian government in the Department of Foreign Affairs and International Trade, as well as in Parliament. So I welcome you all. And to get things started, may I ask each of our panelists in turn to give a brief overview of data regulation from your respective positions. Perhaps we'll start with the EU, and Kristina, might you provide some comments on data governance developments in the EU of recent developments from the GDPR to present?
Greetings from Amsterdam, and thank you, Mark, for this very kind introduction, and thanks to the organizer for having me. This is an extremely important topic, and I'm glad to bring today some insights from EU digital strategy and policy making. I would like to ask organizers to help me with the presentation because my screen sharing is disabled at the moment, so please be so kind to run it from your end, and then we go through the presentation. Yeah. We have seen that the European Union is often heralded, as you said rightly, Mark, as a gold standard. I would say in terms of the GDPR, we are seeing definitely that there are spillover effects in other parts of the world. And let's go to the first slide and see what the GDPR, the next slide please, has brought us so far. We are now 4 years in the GDPR. It's of course not the first instrument that regulates personal data processing, but it continues a longer legacy with the Data Protection Directive, its predecessor. We have had mainly positive reception of the GDPR, and after 2 years of it being implemented, there has been a positive and welcoming review by the Commission. However, we all know that it is not as straightforward. The answer is that the GDPR is a very large instrument, that it has been aptly dubbed by a colleague of mine as the regulation of everything, and it has still not fully asserted its authority on the ground in the EU. Recent issues that are keeping us busy is the working of the one-stop shop mechanism and the perceived, let's say, dragging feet of Ireland as the main hub for international large data-driven businesses. We are seeing issues with enforcement coordination at the level of at the EU-wide level. That means that we are still enforcing piecemeal in the member states. It is not always having the necessary effect on market practices. What we are also observing is a rush of mass claims under the GDPR. Not all of them are successful, but the GDPR allows several or actively legitimates organizations to represent data subjects in court, and these mass claims are certainly a concern from the side of data-driven businesses in the European Union. We are also realizing that the issue of tracking cookies is still not fully resolved. In fact, the UK, which has left the EU last year, they have used the the annoying cookie banners as an argument why they want to improve their approach to data protection regulation in the UK. And there is very, very cumbersome enforcement of compliance by online platforms. In a way, the law is kind of straightforward, but we are seeing that there are protracted legal battles taking place for every little step that needs to be taken to bring online platforms and the way how they are treating their users in line with the GDPR. And some regulators are more active here, especially the French, also Germany, but others are less active. In connection with Canada, we of course know that Canada enjoys an adequacy decision that has been issued in 2001, so it's a bit dated already. It covers these commercial data transfers pursuant to the PIPETA that Mark already introduced earlier. And this will remain unchanged and into force until it is amended, replaced, or repealed. And currently, the Commission has not yet scheduled its review of the decision. The very significant decision of the Court of Justice in the case Schrems II that has invalidated the Privacy Shield has very limited impact on Canada, considering that there is an adequacy decision in place which stays valid. And there are not the same issues, of course, playing in the relationship between the EU and Canada, especially the surveillance issue of electronic communications is not the same. However, there's maybe one consequence out of this Schrems II decision also for Canadian businesses. It seems that there is a new approach by the European Commission on when there is actually a data transfer, because the GDPR applies also to businesses that are established outside the European Union in the moment when they are offering services and goods to European residents, or they are monitoring their online behavior. In this moment, the direct applicability of the GDPR would also exclude that this is at the same time considered a transfer of personal data to yet a third country. So we are seeing that there is a new dynamic which has not yet been confirmed by a court though. So we have to see whether this interpretation will actually hold forth. So we also have seen from Schrems II a number of new developments that should be put in place in order to safeguard personal data when it is transferred to third countries. Some of these safeguards are organizational, some of them are technical. And if you take a look at this menu that includes encryption keys should be held by the data controller, or that there should be additional safeguards to protect the data against unauthorized access, then I would say that they have actually good chances to also develop into some sort of a best practice for how to do data transfers in an international environment. Next slide, please. At the same time, the EU is extremely busy at the moment with policy making for a digital era. And as some of you have maybe already heard, we are calling it increasingly the alphabetical soup. In the European Union, we are cooking an alphabetical soup that consists of the Digital Service Act, the DSA, the Digital Markets Act, the AI Act, and many more. And I'm going to very briefly touch on each of them. They are covering data, artificial intelligence, and online platforms. So what I find remarkable here is that they are trying actually to cover the entire value chain and the different inputs and outputs of data-driven procedures. And we are also clearly recognizing that the EU takes a geopolitical orientation, that they are much more aware of power, of the digital trade imbalances, that they are looking how the EU can salvage digital sovereignty in an increasingly interconnected digital environment. At the same time, we also realized that some other reforms are protracted or probably already downgraded. There is a pending reform of the e-privacy directive that is completely stuck compared to the busy legislative activities on the alphabetical soup. But maybe that doesn't even matter so much in practice, given that the e-privacy directive stays in force as it is. It regulates all electronic communication service providers, and it is, for example, very important for the rules when installing cookies on users' devices without their consent. So in the end, it doesn't have such an impact. Also yesterday, quite remarkably so, the European Commission has put forward a proposal for a declaration on European digital rights and principles, trying to interpret European fundamental rights that we already know from the Charter and give it a digital spin. This declaration has also not yet entered into any binding agreement between the European Union institutions, but we are seeing a strong initiative to give digital rights a proper place in EU digital policy making. We go to the next slide, please. So this is an overview that I have just taken from the internet, but it brings everything nicely into one slide. We are having these two legislative activities, the Digital Services Act and the Digital Markets Act, and they are both a sort of hybrid regulation, because they are introducing they are aiming to introduce ex ante regulation for businesses and companies that have some sort of market power or privileged position. The Digital Services Act is dealing with intermediary services and would, for example, impose quite some obligations on very large online platforms that will be defined and then also declared under the Digital Service Act. It is something that matters for the known large online platforms, and it can cover different types of online platforms, be they app stores, social networks, cloud services, and so on. The Digital Markets Act, by contrast, is more aiming for creating fair, contestable, and open markets for digital services. And it also defines data and power relationships. And for example, it is going to look at whether there is a gatekeeper position that gives a very strong economic position to a company. And if it is declared a gatekeeper, then there would be special obligations on sharing information and giving equal treatment to service providers who are relying on these gatekeeper services for their own business activities. So we are seeing here different definitions, but in a way they are trying to introduce ex ante regulation where otherwise competition law would not suffice and may actually also not apply, because as you know, with competition law you need some sort of a dominant position on a particular market, and data markets and internal markets are often not covered. So this is going to, or this is the plan is to put some practices on hold that are currently disadvantaging other services and users of these large online platforms. What I find interesting is that in the beginning, the big, let's say, fuss was about the Digital Service Act, but right now, most of the attention, discussion, and contestation, also lobbying, has moved towards the Digital Markets Act, which is clearly more impactful for activities of the online platforms. Let's move to the next slide. The European Union is also planning to holistically regulate data. And data is not only personal data like the GDPR already does, but they are trying to see to create a level playing field and more incentives to allow data sharing across organizations and companies. To that end, the European Union is currently building so-called European data spaces. They are having a sectoral focus, and they can be in health, also in science, in agriculture, and so on. These data spaces should actually create an attractive environment for different organizations to contribute their data to these data spaces under some common management data governance framework, and make this data in a well-managed form available for the whole group, or for sector-wide appreciation. In order to do that, the European Union is currently legislating two initiatives. One is the European Data Act, and the second one is the European Data Governance Act. They together set then the major, or the framework that should govern the European data landscape. And what is relevant here is that there is an initiative to give legal recognition to so-called data intermediaries. That would be, for example, organizations that are managing a particular data space. But this comes, of course, with obligations to also uphold data protection rights, personal data in that case, but to also recognize the interests and the conditions for using and accessing such data. This is interesting because we are going to see these data spaces as something that could have a role model function also for other regions, to be much more strategic, so to speak, about first of all, creating a pool of data and then making this pool of data useful in various ways for the whole economy and for business players as well, while upholding data protection law and other rights and guarantees. There would be probably a license involved before a company can request access to such data spaces, and so on. That is also still in the making, and details have to be determined. The AI Act was before that. Can we move to this? Yeah. The third and important initiative here is the European Artificial Intelligence Act proposal. This would be after some successful international standard setting at the level of the OECD, the UNESCO, but also now in the making at the level of the Council of Europe. This would be one of the first legally binding acts, if adopted, that governs AI. I think the most important is that there will be different categories or a graduated approach to different artificial intelligence systems. And there will be a few artificial intelligence systems that will be declared as incompatible with EU principles. They will be outlawed. These are very, very high-risk AI systems, for example, weapons that are AI-driven and so on. So it would be there would be some group of AI applications not admissible inside the EU, but these are rather rare cases. Such applications also without AI would not be allowed today. Then we will have a high-risk category, and they will get significantly regulated. And here the main point is that they would need to undergo a conformity assessment in order to prove that they comply with AI requirements. This conformity assessment is interesting because it is modeled after the conformity assessment we already know in the EU for products that are brought into circulation within the EU. And it would also be something that a foreign supplier of an AI system would need to comply with and first get the conformity assessment. This would be given to private sector organizations that are certified bodies that would need to go and carry out this conformity assessment. The issue here is that it is mainly based on documentation provided by the AI developer or user. And only sometimes it would actually involve a true check of the technical components of an AI system. So it's mainly paper-based conformity assessment with some pockets for undergoing also tougher checks. And with that, we go to the last slide. If I now pull it together and look for what consequences are there for the Canadian businesses, I think for the moment, the GDPR with an adequacy decision that assimilates Canadian data controllers to the internal market of the EU and vice versa, that is the magic formula, the formula that the US is dreaming of, but doesn't have at the moment. And so far that looks as if this is going to be robust. Also because Canada is in many ways in its regulatory framework a like-minded country that maintains a similar level of protection. I wonder if there's any Canadian business at the moment that would meet any of the thresholds of a very large online platform or core platform service or digital gatekeeper that is currently discussed under the alphabetical soup, the DMA and the DSA. If there is one, then I would be curious to hear about that. Otherwise, there would be no impact of this type of power-based legislative initiative on part of the EU. Of course, I highlighted already that there are product conformity assessments for the exports of high-risk AI. That would be, of course, then a new regulatory burden for those that are exporting this high-risk AI, but at the same time, this is something that can be justified in the public interest of keeping EU citizens and consumers safe. There are possibly some positive spillover effects, especially from the DSA and DMA in the EU, because they are going to try to counterbalance the power of large online platforms, and we can learn some important lessons here, what actually creates a better environment for doing business in the presence of large and dominating online platforms. And also, of course, the EU and Canada have their trade agreement in place, the CETA, which is setting the basis for cross-border trade, also electronic commerce in cross-border trade relationships. And this together should actually carry well into the future. Thank you so much.
Great. Well, thank you so very much, Kristina, for that sweeping overview of obviously a great deal of legislation that's coming out of the EU or proposed to be coming out of the EU. I think you've covered a lot of ground. So just to keep moving forward, I'm going to invite Martynas to maybe provide some additional comments on recent EU data governance developments and what it means really for EU businesses. So please go ahead, Martynas.
Thanks, Mark, and hello, everyone. And thanks for inviting, of course, to this event. It's a great pleasure to be here. Yeah, you mentioned that Kristina's presentation was a sweeping one. Indeed, it was. So I will just maybe pick on a few things as highlights to start with. Well, I wanted to start actually, with the latest news. Yesterday, the European Commission tabled its proposal for a declaration on digital principles for the European Union. And yeah, this is a non-binding. It is a political statement by the European Commission with an ambition to have it signed, co-signed together with the European Parliament and the EU Council. Yeah, basically, I wouldn't say there is something new that we find there at first glimpse. Actually, I would say it consolidates what the Europeans have been doing over the last few years into one piece of political declaration, because the principles go about the data protection, privacy. They go about the security of the online environment and things like that. As for the EU businesses, of course, the digital single market for us is key, and of course it has been on the table of the EU policymakers for quite many years already. What I would say from the business perspective, what we noticed that over the last 10 years or so, probably the European policymakers have focused rather on the data protection, consumer protection aspects of digital economy, trusted, secure online environment, rather than promoting the innovative models and free trade. And yeah, the latest push that also was mentioned by Kristina around the digital markets is about the regulation of digital markets, about the regulation of digital services, of provision of services, and data governance. So there is a little bit of shift over the last few years, I would say. Well, Business Europe. Well, we at Business Europe, we do acknowledge the need for these kind of initiatives, because, yeah, I mean, the ever evolving and very dynamic digital economy probably left some questions open. So for the sake of legal certainty, we do acknowledge that these initiatives may bring about the legal certainty and more trust, including when it comes to the investment decisions. However, we always highlight that, guys, hey, proportionality is important. Proportionality is a key word in this sense, and one cannot handle all the risks 100%. This is what we are trying to flag with each and every negotiated proposal on the table. Moreover, we also have to acknowledge that, you know, the European Union is a complex animal, so to speak. We are not a federation. We are 27 independent member states with their own legal architecture and also constitutional tradition. So that is a challenge, and the doing business across borders within the EU, unfortunately, but it's still a challenge. And when it comes to digital, it didn't become any easier. And the point that I want to make maybe today, that with all the buzz around digital economy and the digital transition in Europe over the last few years and respective legislative initiatives, I think Europe has a little bit lost the notion of free trade in the narrative of politicians. It's somewhere in the background, but not more, I would say. And the three examples that I wanted to start with, of course, are GDPR, DSA, DMA. On the GDPR, very briefly, I mean, lots have been said by Kristina, but from the business perspective, what we say that, yeah, overall GDPR is a big achievement in the way it is, and the business community really has invested vast amounts of money to comply with the requirements of GDPR. Expecting it to be, of course, on the other hand, a tool for the single market to function without issues when it comes to transfers of personal data. And here, of course, again, we have to speak about the proportionality. I would say it was and it is still easier for the big companies to comply with the GDPR requirements. And even the big ones, they have to spend lots of money in order to comply. So the SMEs, and that is a big question for Europe, the SMEs who want to scale up, they really face a very challenging forest of the requirements under GDPR to be complied with. When it comes to the overseas, to Canada, of course, the aspect of extraterritoriality of GDPR is important here. And at the same time, in Europe, we use GDPR as first stepping stone, so to speak, in EU's digital regulations. And for the package that we have now on the table of the Digital Services Act and Digital Markets Act, it does have implications. On the DMA, on the Digital Markets Act, again, here we understand, again, the aims, the objectives of the DMA. The European policymakers want to somehow define the rules for the gatekeeper platforms to ensure contestability of the markets. This we do support. The contestability of the markets is an important element that businesses need. And yeah, given also the fact of the statistics that there are some figures that around 61% of the businesses acknowledge that they are either partly or completely dependent on the online platforms, and sometimes they feel that they don't have a possibility to explore all the potential of their growth because of that. So fine, in terms of contestability of the markets, we are supportive of the proposal. But again, when it comes to the nitty-gritties of the rules, we have to say that being a gatekeeper, becoming a gatekeeper, is not a bad thing in itself. And being a gatekeeper does not by default imply that you abuse a situation. So this, I think, is quite an important element. And Europe, what we're trying to say to our policymakers, should not scare off the SMEs from growing, because if you give a perspective that above certain threshold you will fall into hell of requirements, it might discourage the SMEs from scaling up. Another thing is enforcement. Probably we will discuss it a bit later over and over again, but uniformity of the enforcement is key for us. And on the big things and big decisions when it comes to the gatekeeper platforms, we also see the necessity to ensure the centralized, not decentralized enforcement, so that we have legal certainty in the single market of the EU. And to finish here with the Digital Services Act, on this one, we do believe that it is going to become one of the baseline pieces of law on digital economy. Again, I mean, we do understand the reasons, objectives, and why it was proposed, and we do support it broadly. The big debate we have had related, of course, in terms of the online content, whether it should go about the illegal content, or also cover the notion of harmful content. That was quite a big debate. We for sure pushed for the law to speak about what is illegal, because that is what is very clear when it comes to compliance for the business community. And the thing about the responsibility of the platforms that we had, I think it's still ongoing, this debate. It's still ongoing as to how far the online intermediaries, the online platforms, should be held responsible for the content or the products that are sold through the intermediaries. Because what we do not want, and what we are warning the policymakers against, is not to overstep the line of the public function of market policing. Which should not be put on the shoulders of the private operators, because then we might move towards a fundamental reshuffle, I would say, in terms of how the economy and how the market surveillance works in Europe, and we do not think that it is needed. So I will finish my introductory remarks maybe with the point that you may already feel. I think that Europe today is at the crossroads, between how to reconcile the interests of protection of citizens, of data, and on the other side, the freedoms of the single market, the freedom to trade, and innovation-friendly environment that is not risk averse completely. So I think we are at the crossroads, and how we strike the balance in Europe in the coming few years, I think, is really of crucial importance in terms of leadership to Europe, and in terms of how it will affect also the regulatory frameworks outside the EU. I think I will stop here for the start, Mark. Thanks.
Okay, well, that's terrific, and I think we've got a very good view of how the EU looks. I'd like to maybe now take a look at the Canadian situation, and maybe I'll ask Chantal if you could provide us with an overview on developments in Canada, where we're at, and indeed what influence there has been, if any, from the EU.
Thank you, Mark, and I'm delighted to join this group. I've already learned so much, and would like to first tackle your last question, was how does the development in the EU impact Canada? And then we'll look at specifically the law reforms that you just alluded to in Canada. So how European developments impact Canadian law reform, I would say under three angles. The first angle is an economic one. The fact is that Europe represents, for Canadian business, hundreds of millions of wealthy consumers. Therefore, Canadian business is very keen on having a smooth data protection regulatory framework to access the data that is integral, as we know, to the digital economy. The second angle is the issue of adequacy. And in your introductory remarks, Mark, you referred to the fact that there are experts who say that the current Canadian legal framework does not meet the requirements for adequacy under the GDPR. And that is absolutely correct. A lot of us consider that we cannot be complacent about the renewal of adequacy of the Canadian regulatory framework, in particular because of the lack of enforcement measures, as the case is now. Also, we must remember that Canadian adequacy is partial. It only applies to the federal Private Sector Act. It does not apply to the provincial acts. British Columbia, Alberta, and Quebec have their own private sector legislation, which are not considered adequate. In fact, a few years ago, Quebec did apply for adequacy and was turned down. So a company that is governed by provincial, one of these three provincial laws, does not enjoy adequacy. It's the companies that are governed by the federal act that do enjoy adequacy. Also, the other limitation is that adequacy between Europe and Canada, even under PIPEDA, does not apply to onward transfer. So considering the integration of the Canada-US economy, meaning that Canadian companies hold data mainly on US-based cloud services, that portion where the European data goes to the Canadian company, but the Canadian company then transfers it to the United States, is not covered by adequacy, and therefore requires the standard contractual clauses, requires the authorizations that are requested by the GDPR. Finally, the final angle is public opinion. The public opinion is very much looking at GDPR as the gold standard, as the turning point where individual control over one's personal data on the internet has been strengthened. And secondly, where the power imbalance between the user and the organization holding their data is so great that the GDPR has managed through the enforcement regime to rebalance it with, in particular, the creation of fines that are meant to make the misuse of data as costly as the use of data is profitable. So from these three angles itself, you have a Canadian legislation pressure to reform. Okay, so how does it manifest itself? Well, the first manifestation is Bill 64, which amends the Quebec private sector privacy law in a manner very much emulating the GDPR. For example, the enforcement, the fines are practically copy-paste from GDPR. And in fact, it goes even further than GDPR in certain aspects. For example, on artificial intelligence. Artificial intelligence in the GDPR, it is required that any use of automated decision-making systems must be disclosed in the privacy policy, as well as the logic model. Well, the Quebec legislation goes further, creating a right for the individual to obtain access to the personal information that was used to make the automated decision, and the right to contest that use of his or her personal information in that regard. So that's for Quebec. It has been passed. It will come into force. It will start coming into force in September 2022, then 23, then 24 for the data portability right. Then we have the federal legislation, and Mark, in your introductory remarks, you referred to Bill C-11, which died on the order paper because of the elections. It is coming back. The mandate letter of the industry minister directs him to reintroduce legislation to modernize our private sector privacy law. So that's coming as well. Then you mentioned Ontario, who has now proceeded to a public consultation with proposals that are definitely inspired by the GDPR and that are looking for its own Ontario way. And then we have the special committee of the Legislative Assembly of British Columbia that just issued its own recommendation on modernizing the British Columbia private sector law. Throughout, there are some constants and there are some differences. So I will end on that very briefly. The constants, Canada is going to go for an enforcement model. The current model, where the regulator is merely a mediator between the user and the company, making recommendations on the company to improve its data protection practices, that will be history. It is now moving to fines, order making powers, and so on and so forth, so that we do have an enforcement system. The second constant is beefing up individual control. We see those proposals throughout. And also, we see the addressing automated decision-making systems. So this is where Canadian law reform is going at the moment. And as you can see, it is very much taking its cue from the GDPR. With one exception, and I end on that, the proposals from the federal government seems to be resolved to instill the Canadian way. So there could be, and we need to watch for that, a risk of fragmentation of the Canadian privacy regulatory framework. We have to make sure that different privacy acts in Canada remain coordinated, interoperable, and therefore that we maintain harmony in the privacy regulatory framework in Canada.
Excellent. Well, thank you very much, Chantal. And on this point, I guess I'll just turn it over to Mark and maybe ask you to provide some general comments on the Canadian data regulatory framework from a Canadian business perspective, and in particular, what all of this means for Canadian businesses.
Yeah. Well, thanks, Mark, for that. And in the interest of time, I'll keep it quite short so we can maximize the discussion portion. Just to say, first of all, for those of you who haven't come across the Canadian Chamber, we like to say we're Canada's largest business organization. We have companies of all sectors and all sizes in all regions of the country. So really, we can bring to perspectives of the small and medium-sized businesses right through to the large multinational corporations that are in our membership. Chantal provided a great overview of where we are with various domestic Canadian pieces, so I'm not actually going to bother talking about that. Just to say, actually, and Chantal's last comment provided a good sort of segue for this, and that is the proliferation of frameworks. I would say, we're already in a world of seeing this happen. I think there's a whole host of reasons for why there are this proliferation of frameworks occurring, and maybe in the Q&A portion we can kind of unpack that a little bit more from the kind of public policy political standpoint. The one additional piece that I'll table just before I sort of close and turn it back to you, Mark, is around the international trade agreement side. As much as when I started out doing, trade policy work, we were talking about CETA as this agreement that was the gold standard that we were all working towards. In hindsight now, with digital trade and e-commerce chapters getting a lot more ambitious, as they say in the business, CETA actually seems somewhat dated in that regard. So We've seen, for instance, the CPTPP, the USMCA, talking about cross-border data flow provisions. And so that's something that I think, is very integral now to how, the Canadian government is approaching trade agreements and digital policy. And it's something that, absolutely, we think should be embedded in those agreements. We also have the Digital Economy Partnership Agreement. Our government's taken a bit of a look at that and kicking the tires on how we'd want to latch into that. And then we also have discussions happening in Geneva through the WTO through something called the Joint Statement Initiative on E-commerce, which is a real kind of mix of digital trade items there. I'm not really too sure kind of where that one's going to land at the end of the day, because we have sort of the EU, China, and the US all with very different approaches, and how we kind of stitch that together into a plurilateral agreement is anyone's guess at this point. But certainly there's a lot going on the international front. And the comment I'll end off with is something that a member said to me once, which has really kind of stuck with me, and that is, we can deal with one set of bad rules, but when we're dealing with different sets of competing bad rules, that's when it starts getting really sticky, for us. And so I'll leave that with you on the fragmentation point, Mark, and we can perhaps just get to the discussion.
Okay, well, that's excellent, and I think we've got a pretty good overview and a basis for a conversation to go forward on data protection. Or rather data regulation. And I guess as all roads seem to begin and lead to the GDPR, perhaps it makes sense to maybe look at the GDPR. And it's been in force for nearly 4 years now, as we've discussed. The views that I've been hearing is that, at least from the European side on the panel, Kristina Martynas, and also from the Canadian side, is that it's viewed as a good thing, both by the consumer and potentially the businesses as well. But I'd like to ask rather, is the GDPR generally seen as positive in that regard? Do businesses in Europe at least see it as providing them with an advantage when they go out into the marketplace? Or does that view perhaps change given the size of the business? And are Canadian companies perhaps looking at the same thing, looking at it from the Canadian side? So why don't I start off with Kristina and Martynas, if you can maybe just comment on that perception of whether it provides greater value as a business case.
As an academic, I learned that I shouldn't try to assume what businesses think about the particular value of such regulation. I would rather like to make the point that we see that there's still a lot of contestation on the one hand from a very large, often non-EU established organizations that are dragging feet in actually fully complying with the GDPR, and that has led to very protracted legal battles that actually are, I'm a bit worried that we are wasting a lot of resources of judges, of lawyers, of public interest advocates and academics by just trying to get to the point that finally you really only use personal data based on the affirmative consent of an individual, and leave away all the sneaky tactics of dark patterns and trying to shepherd people into consenting into something they never wanted. So what I mean to say is, if everybody would play by the book, then it would also not create this extreme pressure to emulate practices that are actually unfair towards individual users. And we are not yet there. We have the strongest framework in the European Union, and we are still in the process of asserting its authority. There are the very large fines, since we just talked about Canada also adopting an enforcement model that uses sanctions, oversight, and fines, have actually not been as persuasive as we would hope. In a way, they sound enormous. What the CNIL, the French data regulator, dishes out is several hundreds of millions. Yeah. But in a way, in the turnover of a company of the size of Alphabet or now Meta, it kind of becomes still not extremely persuasive.
Okay, thank you, Kristina. Martynas, can you maybe comment on that? I think you already alluded to it on some of your opening remarks, but.
Okay, I mean, one of the main goals of GDPR, as we understood and expected, was actually to harmonize the data protection rules across the EU, which would, of course, by default facilitate the trade in digital services within the single market of the European Union. And of course, this was why the business community in general, I'm leaving, the nitty-gritties, but in general, we were supportive of this piece of legislation coming into play. Our expectations did not expect magic, but still, I would say they were reasonably positive. Today, what we have, I wouldn't call a business case because that was your question. And of course, there are many more hurdles than a business case in that. I alluded already to the challenges that the small businesses especially are facing. But there are also some examples, I can give a very concrete one, like, on the Article 42 of the GDPR, which actually enables member states to support the demonstration of compliance through their own mechanisms, through certification, voluntary standards. And unfortunately, but we have examples where some of the member states go with this kind of approach too far, and businesses find themselves that they have to do the certification in 27 member states or at least 20. That is not what we expected from the GDPR when it was negotiated and finally adopted. So implementation. Enforcement as well. The data protection authorities in the EU were not ready, we think, and there is quite a significant question of the resources. So staff knowledge, interpretations, that is really quite crucial. And enforcement, we would say, of GDPR is still maturing. So there is still building up exercise, learning exercise. And last but not least, I will mention the European level guidances, and we have the European Data Protection Board that is in charge of guidance for the national data protection authorities in terms of the application of the GDPR. We did have big debates and problems with the European Data Protection Board guidances, draft guidances, when they threw them into the public domain for consultations, because again, they interpreted and went the GDPR and went beyond the GDPR provisions. This is our view, which should not be the case when we have the regulation, which is directly applicable in Europe in question. When the European Data Protection Board goes further with interpretations, then in a way it opens up some Pandora box also for the national data protection authorities. And if there are questions which are unanswered, the national data protection authorities, they come into play with their own interpretations. And this is, this reminds already what my Canadian colleague mentioned. We are entering the forest of competing bad practices and decisions. We also had, for example, the cases when there were cross-border cases, the cases of cross-border personal data transfers, but National Data Protection Authority of one member state would take a unilateral decision without even consulting the other member state involved. So where is the single market? That was our question. What is it? We expect the harmonization of data protection framework, and we are now in this situation. So definitely there are challenges, and even though largely we consider that the businesses operating in the EU have done tremendous job in attempting trying to comply with the GDPR. There are still many questions, and I think that this public-private dialogue on this still has a very long way to go.
Okay, well, that's so let's take maybe the point as a lesson from the EU experience. So obviously it was an attempt to harmonize the rules. That harmonization hasn't yet come to fruition. One hopes that we're moving to that, but clearly more work needs to be done. Are there any lessons, perhaps Chantal and Mark, from a Canadian perspective that we might want to look at, given that, as far as I know, there's no equivalent to the European Data Protection Board being envisaged in the new Canadian legislation or the Canadian regulatory framework? So what might or could be done to try to recognize this coming? Or is data protection or enforcement and regulation just destined to be, fragmented?
I think it's both. So it's interesting, I must say, that listening to Mark, it's music to my ears, what he said, because I am about to release an article on 10 trends in Canadian privacy law reform. Trend number one is that I identified as the risk of fragmentation. So hearing Mark say the same thing, I feel, of course, that I'm not alone. I believe that we need, on the one hand, to accept that different jurisdictions proceed on the basis of different policy positions as well as different legal traditions. Therefore, I think we need to accept that there is a natural effect of different rules. The EDPB has shown, in my view, to be incapable of countering that, because, as Martynas just said, they keep going, national authorities keep going their own way anyhow. So to me, there are two solutions or two action items. Number one, because in Canada we are still in the process of reform, business must impress upon the legislation makers the importance of ensuring interoperability. Saying, okay, you want to go each on your own? Well, then at the very least, you must incorporate in your privacy law a provision that clearly defines its scope so that there is not a conflict of application. For example, Section 3 of the British Columbia Personal Information Protection Act says it does not apply where the federal PIPEDA applies. Okay, so at least, even if there are two applicable rules for one company, they are clearly defined. So that's the first thing. We must impress upon the legislation makers the need to harmonize, to come up with a solution. And the second action item is actually to prepare internally in each organization a compliance system that actually does address the reality of different requirements. So as you can see, Mark, there's a bit of resignation in my stance as a former legislation maker, because I was in government for so many years doing the policies that ended up in legislation. I believe we need to accept, particularly in view of the European experience, that jurisdictions will have an imperative to go at least a little bit their own way.
Okay, that's very clear. Mark, do you have anything to add to that?
Yeah, so maybe just coming at this from a bit more of a political, standpoint. And this kind of, again, picks up on Chantal's, point about the imperatives. I mean, when governments are facing, a privacy breach in their jurisdiction, whether it's a government entity or whether it's a private sector entity, the political, pressure grows to act, to be seen to be doing, something. And that's the really important part of that sentence: be seen to be doing something. It might not always be constructive, might not always be the most advised long-term solution, but we need to be seen to be acting on this because it's a political problem. The other thing I would say about the coordination piece within Canada is that I would submit that in terms of the parts of the federal and provincial governments that are leading on privacy reform, they're not the parts of government that I think have institutionalized interprovincial cooperation into their work. And so they're just not used to, I think, thinking interprovincially and coordinating with their provincial counterparts. And there is a tendency sometimes for people to sort of lay everything at the feet of the intergovernmental minister and say, oh, well, they'll be able to kind of knock heads together and figure this out. But in Canada, I mean, our intergovernmental ministers have so many things that they're dealing with, right? They're dealing with, CPP issues and health transfer payments, and privacy is just going to kind of fall down the radar as this kind of, techie, geeky subject that, politicians just don't have time or the capacity to deal with. And so I think those are some of the political realities that have led to what we're seeing in Canada with, jurisdictions popping up and doing their own thing.
Can I add something? I mean, that is such a good point as to where the seat of provincial federal coordination rests in government. I will just add this, that in March 2021, the Minister of Innovation, Science and Industry, François-Philippe Champagne, who is responsible for introducing the new privacy law reform federal for the private sector, did say that he felt harmonization of provincial privacy laws was critical to the Canadian economy. So let's just hope that he actually implements his own guidance.
Okay, well, given the limited time that we have, just make sure we get in some audience questions, participant questions. I'd like to maybe just turn to the issue of the new legislative initiatives of the EU, the alphabetical soup, as Kristina referred to it as, and really looking at it from a Canadian perspective. Are there similar types of initiatives taking place in Canada? Chantal, you mentioned with the Quebec legislation, there's definitely a looking at the artificial intelligence or automated decision-making. So there's some elements there, but in terms of a wider sweep of legislation, is there anything in the works in Canada, and if not, is there pressure to do that, Chantal or Mark?
Mark, you want to go ahead?
Yeah, so I think what we're seeing, and this is like even just within the federal government, is there are a series of things happening in the digital space. I don't think in Canada we're going to see like an omnibus digital, market type approach. I mean, the government's indicated, for instance, that what was Bill C-10 in the previous parliament about online platforms, that's coming back, as a standalone. Privacy notice C-11 in the last parliament, coming back as a standalone. We noticed also, for instance, in the mandate letter for the Minister of Industry that taking a look at the Competition Act and reviewing, that as well as seems to be on the table, that would be coming as a standalone. So I think different bits of government are going to be doing their own thing. And again, I don't foresee there being this omnibus approach in Canada that's looking at a digital market act type equivalent.